Assalamualaikum and hi, my name is Emilia Archana binti Amzari, and I will talk about the three cases, which is the first one is the Hall versus Lorimer. The issue of this case is whether Mr. Lorimer's engagement constitute the contract of service, which is employing him, or the contract for service, which is the self-employment. So the argument stated that for the self-employment, Mr. Lorimer operate independently, taking the financial risk and managing his own business affair without reliance on the single employers. Against the self-employment, the Inland Revenue argued that his lack of personal equipment and the nature of his work indicate an employment relationship, suggesting that he was effectively an employee due to the short-term nature of his contract. Next is the fact of the case. Mr. Lorimer transitioned from the full-time employment with Molinaire to freelance work for various productions company between 1984 and 1989. He engaged in over 800 days of work, primarily as a vision mixer without long-term contract. His earnings were assessed under Schedule E by the Inland Revenue, which prompted his appeal to classify his income under the Schedule D as a self-employed income. The court upheld the Special Commissioner's decision that Mr. Lorimer was a self-employed. So through this case, the principle established is that the employment status should be determined by evaluating all relevant factors collectively rather than mechanically applying a checklist. So the extent to which a worker is in a business on their own account is crucial in distinguishing between employment and self-employment. Next is the case of FY versus DJIR in 1988. So the issue is whether the payment received from the contract is the employment income or the business income. So the fact of this case is that a professional public entertainer who was contracted by a hotel to perform was held to be employed under a contract of service because her show was integrated with a hotel business. Therefore, she was prohibited from obtaining alternative employment during the performance period without the consent of the hotel. The hotel provided the musical backing and controlled the manner of her performance. She was paid a fixed remuneration according to her contract, which also stipulates other conditions as the duration of performance, her appearance, and forbade her to engage in alternative employment. However, the plaintiff argued that she is a professional public entertainer. Her floor show is a profession, hence the payment received from the service provided should be under Section 4, Subsection A, business income. The court held that the payment received from the service provided is under employment income and not business income. It is due to the degree of control exercised by the hotel. And next is the case of DJIR versus Dr. Ahmad that happened in 1988. So the issue is that whether the Dr. Ahmad is eligible for resident of Malaysia under the Income Tax Act 1967. So the fact is that if an individual arrived in Malaysia on 1 October 1991 and left the country on the 10th April of 1992, he would have been in Malaysia for 92 days in 1991 and 101 days in 1992. So the total days that he have been in Malaysia is 193 days. Okay, the argument states that under Section 7, Subsection 1, Subsection B, an individual with a period of stay of less than 182 days may be eligible to be a resident in Malaysia. Is linked by another period of 182 days or more consecutive days in the immediately preceding year assessment. 182 days consecutive day period could be overlapped on the two basis period. Okay. So the judgment state that since his periods of stay exceed 182 consecutive day, he will be qualified as a resident for the both year of assessment 1992 and 1993. So as a result of the decision in the case, Section 7, Subsection 1, Subsection B was amended and made a clearer so that the 182 consecutive day period must be fall in the basis year immediately before or immediately after a particular basis year.
Hi, my name is Nur Farina. So I will continue with the case of Aspek Lubricants Malaysia Sdn Bhd versus Ketua Pengarah Hasil Dalam Negeri 2007. So in this case, the company, which used to be known as Kestra Malaysia Sdn Bhd, has a business that doing the blending and selling the lubricants for motorized vehicles. So during the year of assessment, 1989 to 1992, the company gave away the promotional gift to the customers and dealers. So the gift that was given included mugs, t-shirts and umbrella which carried the company's logo and as appreciations to the customers and dealers for buying their products. So the company Aspek deduct the expenses for this promotional item from the gross income of each year of the year of assessment, and the Inland Revenue Board initially allowed these deductions but later rescinded the deductions as it was considered as the entertainment expenses, which is disallowable. So the taxpayer appealed it to the Court of Appeals, and the judges examined the true nature of the transactions between the taxpayer and customers, and they came up with the conclusions that the expenses incurred in respect to the customer's item did not amount to the entertainment within the Section 39, Subsection 1. The next case is GBH versus Ketua Pengarah Hasil Dalam Negeri 1994. In this case, the issue was whether the duties brought back to Malaysia is taxable. So the employee, who has a Hong Kong source, was exercising an employment in Malaysia. So he was required to service dealers in other countries besides Malaysian dealers. So when the assignment was not completed in the countries that he was assigned to service, it was brought back to Malaysia for further work and the preparation for the monthly reports to be submitted to the headquarters in Hong Kong was carried out in Malaysia. As the duties from outside Malaysia and the Malaysian duties cannot be separated, it was ruled that the overseas duties were incidental to the exercise of employment in Malaysia under Section 13, Subsection 2C. So it was held that the income will be aggregated to the employment income in Malaysia.